I only told the audience about some of the things that you had done. Elaborate on what you did with these ordinances, these small town sex offenders.
Well, what actually, how I got involved in this particular issue is I had noticed probably a couple of years ago that then Attorney General Greg Abbott, now Governor Greg Abbott, had written an Attorney General opinion in 2007 concerning what authorities cities, large and small in Texas, had to write what are known as residency restriction ordinances that applied to sex offender people who had to register as sex offenders under Texas law. And that is Greg Abbott's conclusion, and he signed the opinion personally, so although I don't know that he researched it, he did sign it, was that although home rule cities over 5,000, had authority to enact such ordinances so long as the legislature had not expressly prohibited them from doing so, that what are known as general law cities under 5,000 did not have that authority, and it's actually part of the Texas Constitution, and it goes back to something called Dillon's Rule from 1876. And several years prior to that time, there were a lot of states that were adopting new constitutions after the Civil War, and there was a question of where control should be in local communities or the state capitals of each of these states. And there was kind of a railroad boom going on, and so there's a question of who was going to take the bribes, the people in Austin or the local city officials. And the Texas Constitutional Convention in 1875 decided they'd rather have a centralized control over these small cities, and whether they would grant easements and things like that for railroads, and just generally for any type of ordinances. So I didn't see it really coming up necessarily in any class, and I had at that particular time that I came across it, that is the Attorney General opinion. About a year or so later, I was contacted by Mary Sue Mulliner, who is the president or executive director of a group called Texas Voices for Reason and Justice, which is an advocacy group for registered sex offenders and their family members and other people affected by registration. And she told me she had had all kinds of calls, and people just couldn't find a place to live because the large cities, kind of a domino effect across the state of Texas, had enacted them, and then now the small cities had done it. And so people, especially if they had to have transportation and get to work in small communities, large communities, they just couldn't find a way to survive. And a lot of them had wives and children and things, rendered homeless basically. So I told her, I said, well, I don't know how many of these general law cities have done it, and I'm not sure I really would want to expend the time. Do you have volunteers that can look and find out how many cities in Texas have done this, notwithstanding then Attorney General Greg Abbott's opinion? She assigned the task to several members that are very active members of Texas Voices. And within a couple of months, they got back to me, and they'd gone through every general law city in the state of Texas, some of which had online city ordinance codes through MuniCode or Franklin Publishing. A lot of them didn't. So it actually took phone calls and things like that. And there were about between 75 and 80 general law cities in Texas that had done that. Almost all of them had done that in response to Attorney General Greg Abbott's opinion saying it was illegal. So I'm confident that all of them were aware that it was illegal when they did it, but they just did it anyway. So I told her that I didn't really think that was a manageable number one. Number two, I wanted to focus, if we could, our attention on general law cities under 5,000 that had registrants that were living in the towns under grandfather clauses of these ordinances or nearby and had a desire and were being prevented from living in those cities. And so we winnowed the number of cities down to 46. I sent a demand letter and provided each of those general law cities with 45 days so they could, of course you're required to give notices in these kind of lawsuits against cities, but I gave them 45 days to go ahead and meet, and then I included and kind of explained why it was illegal, and then included a copy of Attorney General Abbott's opinion. And I suspect that probably virtually every one of those cities had, both the voters and city officials were very strong supporters of now Governor Greg Abbott. So I'm sure it was quite a surprise to them to see him actually articulate a correct statement of law that benefited someone other than them. Nonetheless, 20 cities before the 45 days expired did repeal. we filed a suit, or I filed a suit on behalf of Texas Voices under association standing for their members that were registrants. 14 suits against 14 cities. Within about a week, three of those cities that had been served said, hey, we didn't really know you were serious and you were ready to repeal this thing. And I said, okay, you can repeal it, but you're going to pay me back my filing fees and my process server fees. And then I want it in writing. I want to see not just minutes, but I want to see an ordinance that repeals it. And they did. We have cities remaining, 11 cities remaining from those first 14 that we sued. And we've got about a dozen or more. We've actually discovered some additional cities that are kind of on our list. And the litigation's going on. They're in all different stages. We've won pleas. We've won hearings against pleas to jurisdiction that have been filed by some of the cities, and they're on appeal. And we've got a question of whether or not our registered members of the organization, that is Texas Voices, should be allowed to give affidavit testimony in response to pleas to jurisdiction pseudonymously. We have particular concern in the Denton County. There's actually 4 cities in Denton County that I sued. There's a radio broadcaster in Dallas, or actually Fort Worth, WBAP, that once news about this came out, did 2 full days, morning and afternoon, making comments about me, which I'm kind of used to, but also threatening to read the names of the registrants in the cities that had been sued so people could do their own investigations to find out which registrants were supporting our lawsuit. And that caused some problems with some of my witnesses that are members. And so I told them, of course, I expected that to come up, and I assured some of them that I'd do what I could, and I wouldn't expose what their names were because they have families to protect, and they're not just registered, but it's one thing to be a registered sex offender. It's another thing to have a picture in the paper and be known to someone who is actively supporting your individual rights under these circumstances. I was denied a motion to seal the record and for a protective order against my opposing counsel. I was going to, of course, the opposing counsel would be entitled to the information, take depositions and whatever else. And if I had a hearing, I'd have live testimony. But my opinion is opposing counsel just thought they'd take advantage of the fear factor to try to scare us away, and it wasn't really going to scare us away. And we do have witnesses that don't really care whether they're publicly exposed because they're single or whatever. But anyway, that's one issue that we have actually in the Second Court of Appeals now. But so far, I mean, like I say, it's, we've had cities from as far west as Van Horn, Texas, way down Brazoria, down in the valley, cities over in East Texas. So it's the cities are not isolated in one particular geographic area in Texas. It's all over. And we know, of course, we knew going in, every session of the legislature since the Abbott opinion came out, the Attorney General opinion, there have been one or more bills filed in the Texas sessions of the Texas legislature, and each one of them, none of them actually have prevailed. Last session, there was one that got out of committee, but it never got a vote. We expect it will be a controversial issue, and probably a lot of testimony heard by at least one or more committees next session. But we have gotten impressions from some of the bills through newspaper articles. Representative Murphy is one that's working on something that would be somewhere in the middle. And my position is it's one thing to have individualized assessments if people are to determine whether people pose some kind of threat to anybody. But to have a blanket, anybody that registers, of course, they don't do an individualized assessment to require you to register. You just have to either be on probation, even deferred, or you have to be convicted and be on probation. And of course, some people there's 2 categories. A lot of people have to register for 10 years after they've finished either their sentence or their probation. Others have to register for life, depending on the offense and the age of the victim. Right now, we've got 87,000 people in Texas that have to register, and that is increasing. We're expecting it will be over 100,000 probably within the next couple of years.
Where's the city of Louisville?
Okay, the city of Louisville is a home rule city because it's over 5,000. Right now, it's kind of had torturous procedural history, but we were told by, the district court initially granted a motion for summary judgment by accepting or having accepted the defendant city's argument that someone has to be convicted of an ordinance or a statute before they have standing to sue. That, even though I provided 5 or 6 Supreme Court cases that expressly said that was not the case, and of course there's all kinds of litigation, marriage equality cases where you're not going to be convicted of anything by being deprived of the right to marry, but you still have standing. And of course our position was that people that have to register that can't live in these towns or are run out of town under threat of criminal punishment had standing, and Fifth Circuit reversed. We argued it. We went back a second time, and the question, really the primary question, was whether someone has a liberty interest to reside, everything else being equal, in a location of their choice. And the district court the second time, after the remand, ruled that a liberty interest, a protected liberty interest under the 14th Amendment, which right now includes a right to a hearing before your driver's license is suspended, a right to a hearing before you can be suspended from a public school, things of that nature, that the standard for liberty under substantive due process and the showing that something is a fundamental right is necessary in order to have a protected liberty interest for purposes of a due process procedural protection. And oddly enough, the district court was reckless enough about it that he cited a minority opinion written by Justice Scalia in support of that position, even though it had been rejected by a majority of the Supreme Court in that very case, and cited it as a majority opinion, even though it was a dissenting opinion.
What judge was that?
This is, well, it's Mazant actually is the one, and oddly enough, he was a magistrate. It's in the Sherman Division of the Eastern District of Texas. He was a magistrate that recommended dismissal on the requirement that you be convicted of the statute before you have standing, and which was accepted by the district court, Ron Clark, at that time, then was reversed. And in the interim, Judge Mazant, former magistrate Mazant, was elevated to a full district judge, and the case was reassigned to him. And it was I was kind of disappointed. Even the first go around, there was plain error. The Fifth Circuit found plain error on some facts because he was cutting and pasting facts from the brief of the city of Louisville's council without a citation of the record, when the record showed the opposite was true. And the Fifth Circuit kind of came down on him pretty hard, saying, you took this directly from the opposing counsel's brief. We said, as Mr. Gladden says, there's no support for this in the record, and found it clearly erroneous, that fact. Although it was not really a directly material fact, it was significant, I thought.
How many years have you practiced?
I got my law license in May of 1990, and so I guess we're probably around, 26 years?
Yeah.
A little more than 26 years.
I don't know why. I thought
You thought I was older?
Yes.
Well, I mean, as you may know, my father was a lawyer in Texas, and so I kind of grew up around it. And my brother's a lawyer. My nephew, my brother's son, is a lawyer. So I kind of grew up around a lot of lawyers. I didn't initially intend to become a lawyer. Actually, I was a musician, got a degree in jazz studies at the University of North Texas, and had some trouble with the university police up there while I was in school. Not so much as me doing anything wrong as being a bystander saying, hey, we're watching everything, we'll be witnesses for you, and then these cops would come over, hey, you want to go to jail too? And what for? We're going to arrest him, that kind of thing. And so I ended up suing. My dad wouldn't file suit on my behalf when I was a college student until I graduated. He made that as an incentive for me to get the hell out of law school, out of undergraduate school. Which I did, and I went to California for a year, and decided I would dedicate a year to a music career in California, and then reevaluate after a year. And after a year, I had been out there and working out jobs, didn't get a lot of work, did some internships, stuff like that, some music studios, but my actual degree was in arranging, and jazz studies, and you could have an emphasis in performance or arranging. And at that time, the studio recording, as far as arranging work goes, everything had gone digital, so they were no longer hiring live horn players or string players or woodwinds or whatever. So you'd have a one-man person that would just arrange the music, or maybe not even write it out, but would have 64-track recorders, and then they could sample what a violin sounded like, and then play it on a keyboard, and it sounded just like it. So they work for the music business as far as that kind of work, television and stuff. They still have a big bunch of movies I know that they used live for real strings and woodwinds.
What did you play?
I played guitar. I started playing guitar when I was about 12. When I was in high school, in two separate groups, in my sophomore year and my junior year, was in groups that won my high school talent show. And then I graduated a year early and went to Denton to study jazz. And I don't play guitar much anymore. It's for me. A lot of people say, "Oh, well, why not? You spend so much, dedicated so much time and all that stuff." And to me, it was a thing for me playing guitar that was kind of like if you were aspiring Olympic swimmer or something, and the time that I was putting into it every day, if I didn't do that for 2 or 3 days, I could see how much I'd lost, and it's just something where, it wasn't just a hobby, it was something that was serious for me. So, I cringe if the guitar around, I pick it up and try to play something that just really bothers me. And I could probably get back to where I was if I spent 6 months or so doing it nonstop, but I just didn't have the time.
What is your practice like? I mean,
I'm almost exclusively criminal defense. My practice is a lot like my father's was. His was primarily criminal defense, but he also got into criminal defense-related lawsuits, whether it was Section 1983 cases for excessive force or things of that nature. He did a lot of other things too. He did voting rights. Just about all my practice is criminal defense. It's pretty equally balanced between appellate writing as well as trial work. Probably do a little more trial work than I do appellate work, but I've been doing a lot of writing, it seems like, lately.
What's you have fought for to undo the Roderick Johnson strict liability idea. Talk a little bit about that.
Yeah, Texas, it's kind of an interesting thing. In the late 1800s, or late 1800s, at that time, late Victorian period, not just in Texas but everywhere, it was illegal to have sex out of wedlock, and adultery was also illegal, and so it's fornication, adultery, and there was a real confusing thing that happened is that when they ran into situations where people were accused of statutory rape or now sexual assault of a minor, and they didn't have proof to show that the person had a culpable mental state where he knew the age of whoever he or she was having sex with that was underage, they did something that I refer to as a transferred intent or transferred knowledge, is that they could say, well, you knew that you were violating the fornication statute because you weren't married, or you were married and you knew you were having sex out of wedlock, and so they could transfer the mens rea from another offense that wasn't charged to substitute for a lack of knowledge about the age of the victim, or even consensual victim, mostly consensual. And that was the original rule, and that was the rule that actually was adopted in Texas at that time, say 1880 probably. Over the years, by the 20s, it's kind of like playing a game of telephone. The rule just they lost sight of the fact that they need to have transferred intent or some culpability that was borrowed from the other statutes. And by that time, they had repealed the laws against fornication and adultery. And so they were just faced with a thing where people just had no knowledge that they were doing anything illegal, and even would have affirmative evidence or proof to show that they had every reason to believe the person wasn't underage. And in Texas and several other states, they cited back to earlier decisions without carefully reading them. And actually it was, the original rule about the transferred knowledge that was borrowed in America came from a case that was 1875 called In Re Prince. And that's where they said that because you knew you were committing adultery or would have known or whatever, we can use that as a substitute for a lack of knowledge. And that's the premier case that everybody, the first cases in America and Texas and other states, relied upon and adopted. And then, like I say, as they got farther away, partially because that English decision wasn't readily available, I think, to some of the western states that had not as much access to English law libraries, I guess. They just ended up making it strict liability. In the mid-'60s, California had a case that said we're not going to have the strict liability anymore. We're going to allow an affirmative defense, that if you could show a reasonable person would have objectively and subjectively felt like or known that they or thought reasonably that they hadn't violated the law in any way, or the knowledge of the age of the person they're having sex with, it's a defense. A lot of states have fixed the problem through statutes. U.S. Supreme Court has never addressed the case. They haven't come close to it. For example, the Tracy Lord's case, where it turned out she was not of legal age when she made a lot of porn videos back in the 80s. The feds prosecuted someone for distributing those videos when it turned out after the fact that she was underage. And the U.S. Supreme Court ruled that we are going to imply a scienter requirement for anyone who's selling or distributing pornography where it turns out one of the actors is underage. And otherwise we'd run into grave constitutional concerns about holding someone strictly liable who had every reason to believe that the porn videos they were marketing were legal. But that's as close as the U.S. Supreme Court has gotten. And like I say, now there's so few states, Texas and maybe a handful of others, that still have that strict liability. I don't know that an issue is ever going to create the kind of what I would refer to as a horizontal conflict that would inspire the U.S. Supreme Court to grant review on it. We did petition in the Fleming case, but they did not grant review.
I high hopes for that.
Yeah. I mean, obviously I did too. But at some point in time, it doesn't make a lot of sense. And like I say, we've gotten, we're up to 87,000 people in Texas that have to register. Probably not a real high number of them are in the situation that Mark Fleming was in. But it's kind of, my feelings about it is, it's one of those unfortunate situations where the political ambitions of people who are officials that want to enact these ordinances take precedence over whether residency restrictions even work. Every study that's ever been done by the Justice Department, by even advocacy groups for children, have recognized that residency restrictions don't make children safer. They actually make children less safe. There's a couple of the Jacob Wetterling Resource Center in Minnesota is strongly against residency restriction ordinances, among other organizations, because it creates an instability in the offender, renders them homeless. Usually they go off the grid because they no longer register like they would be. Not to say that registration necessarily makes anybody safer either. It certainly helps apprehend people if you think they're a suspect after the fact or have reason to believe they are. But, online solicitation, what difference does it make whether the person lives within 3,500 feet or 1,500 feet or whatever of a McDonald's that has a playground? Because, of course, the definition of places where children commonly gather, which creates the criteria from which they measure a distance to banish people from entire communities, and is so inclusive. You could live near a hospital because it's got a maternity ward. You could live near a McDonald's that has a playground, a church that has a nursery, whereas, just about I've even had the city of Saginaw. Originally, I had a client that had gotten out of prison, and it was causing him problems because he couldn't live where he had lived before he went to prison. He was a relatively young guy. And they were claiming a drainage ditch at the end of his block was a public park. Even though it wasn't a public park, it was a drainage ditch, but the city had an easement for the drainage ditch. And they just declared that was how we're going to enforce it. And I said, well, you might have some trouble. And they thought about it and backed off. But, it's a hysteria kind of thing. And you've written the methods for work. I've read the stuff you've written. It's all based on fear. And if people really look at the facts, they realize that they're not helping anybody, and they're hurting a lot of people that have already been hurt, that are trying to do right. They pay their debts to society. And it's really in society's best interest that we allow them to do that and move on and be productive members of society.
What got you into doing this?
Yeah, and it's really not just in this situation, but in just about every situation. I found myself in as a practicing attorney, and before that I mentioned earlier at the presentation, I don't like bullies. And it seems to me I run into a whole lot of bullies in the criminal justice system, people that don't seem to have any morality if they think that they're on the right side, whether it's religious motivation or whatever, and they're usually, it arises out of either their own ambitions or just fear. And they're going to convict people if they've decided they're guilty, if they have to manufacture evidence or plant evidence, lie on the witness stand. Any criminal defense lawyer will see that witnesses for the prosecution, maybe not knowing, maybe the prosecutor doesn't know, but they will exaggerate facts, leave facts out that are important, shade the facts, shade the truth, because it's, to them, the criminal justice system is a competitive sport, and any trick or game they can play to accomplish their goal of convicting people, they think is okay. I don't practice law like that. I don't know of any criminal defense lawyers that do that. Not to say that there might not be some, but it's just, I just don't like bullies, And if I wasn't a lawyer, I still don't like bullies.
Well, I'm glad you're out there, man.
Well, I appreciate it.
Is there anything I'm missing you'd like to say?
Well, there's, kind of extending what I just said. I'm probably, of course, I know criminal defense lawyers, if they didn't know going into it, they probably learned after becoming criminal defense lawyers, is that people who are accused of crimes are not all faceless people that, well, let me put it this way. I know that most of my friends that aren't lawyers, if somebody breaks into their car or somebody burglarizes their house, they don't think of an individual doing that and wonder why an individual in an individual case would do that. They have a faceless idea or concept of what a criminal is. It's someone who doesn't want to work for a living, who is taking advantage of them and depriving them of things they worked hard to get and things like that. Because my father was a criminal defense lawyer, I grew up around criminals that he would basically barter with. If they didn't have money to pay him, we had a farm, and so on the weekends I'd be out there mowing on a tractor, and they'd be out there on a tractor taking turns with me. And most of those cases were dope cases. They weren't violent offenses. Some of them were theft cases. Some of them were burglars. But I was around them and realized they screwed up. They made a bad decision. It could have been the other people they were hanging around with at their relatively young age that led them down astray the right path. But I have never, because of being around them, when I think of a criminal, even when I've had my own car broken into, I don't have the very deep-seated hostility towards whoever that was. I think it's a dumb kid. I think it's somebody who needed the money worse than they thought I needed it. And so I don't really see it in the same way as people who are not lawyers or who didn't grow up in the environment that I did. And, we've got a criminal justice system. I think everybody's better off if they did approach it in terms of individualized assessment of culpability, whether people are salvageable and a little bit of forgiveness, I think, sometimes too. So that's all I've got.
All right, man. I'm glad you're out there.
Well, I appreciate it. Thanks, Steve. You bet.